Welcome to the law offices of Chris M. Ingram's Immigration News Show. Today we ask, in a system where a single wrong date or fee can disrupt your entire career, how do you use the booming innovation economy to stop playing defense and finally secure your place as an undeniable asset to the United States?
We would like to thank attorney Chris M. Ingram and staff at the law offices of Chris M. Ingram for their hard work in preparing the research for this show, which draws on a wide variety of news sources from both sides of the aisle, providing a balanced view.
Attorney Ingram is also a vocal advocate for the rights and protection of immigration applicants, although our coverage is designed to be nonpartisan.
Please don't forget to like, follow, and subscribe to our channel. We're also on Spotify, YouTube, LinkedIn, Facebook, X, Reddit, and Instagram, where we're growing rapidly thanks to our social media team.
You can also visit our website on www.breakthroughusa.com. We'd love to see you there.
Disclaimer. Please note that this presentation should not be intended as legal advice for your specific situation. If you, a friend, or a family member would like a free consultation, you can visit our website at www.breakthroughusa.com and schedule an appointment.
We'd love to hear from you and help you, if we can. We'd also like to point out that this presentation was created using AI hosts. Okay, let's dive in.
Let's do it.
So, let's just be real for a second. If you are tuning into this deep dive, you're probably, you're the kind of person who solves impossible problems for breakfast.
Right. You're a STEM professional.
Exactly. You deal with like nonlinear equations, or you're debugging thousands of lines of code, or I don't know, mapping genomes. Complexity is kind of your comfort zone.
Oh, absolutely. The people listening to this are, they're used to very high-stakes intellectual work.
But then, and I think everyone listening knows this exact feeling. You open up a government form.
Yeah.
And suddenly all that intellect just feels useless. You're staring at a PDF, wondering if checking the wrong box is going to literally get you deported.
That's terrifying.
It is. It feels less like a standard legal process and way more like a second full-time job.
Because it is a second job. And frankly, it's usually way more stressful than the actual job you're being paid to do.
Right.
The legal research from attorney Chris Ingram and his team really hones in on this paradox. You have these brilliant minds who can navigate the laws of physics seamlessly.
But the laws of bureaucracy.
Exactly. That's where the administrative friction just completely stalls them out.
Administrative friction. That is, that sounds like a very polite way of saying the system is actively trying to trip you up.
Well, in a way, yeah. But the research from our legal team suggests it's not necessarily malice, it's just extreme rigidity.
Right.
They point out that for international talent, the biggest threat to your career usually isn't some massive, headline-grabbing change in immigration legislation.
It's the small stuff.
It is entirely the small stuff. It's a fee that's $10 off, or maybe a form that's technically just 3 months out of date.
Which, for a scientist or an engineer, is just incredibly infuriating. In the lab, if you're off by a tiny margin, you adjust your variables and you just rerun the experiment.
Right, but in immigration, you don't get to just rerun the experiment.
No.
At least not without a massive cost. Attorney Chris Ingram's team highlighted the real-world consequences here. We aren't just talking about getting a polite, please resubmit email from the government.
Yeah, if only.
A rejection due to a bad form triggers a whole chain reaction. It breaks your employment continuity.
Which is basically the legal way of saying you might lose your entire status.
Exactly. And it disrupts research grants, it delays paychecks, sometimes it even resets the clock on mandatory waiting periods, so you have to shift your mindset.
From what to what?
From, I'll just quickly fill out this paperwork, to, I need to architect this application with the exact same precision I use in my engineering work.
I really like that phrase, active architect. We're definitely going to come back to that concept. But first, we need to talk about the actual landmines.
The policy traps.
Yeah, the legal research identified 3 very specific policy traps that are active. Right now, we're talking March 2026. These are the things catching incredibly smart people completely off guard.
Let's start with trap number 1.
Right, the cost of speed.
This one revolves around the Department of Homeland Security's Bright Line rule regarding premium processing fees.
And whenever I hear bright line rule, I just assume that means zero tolerance, right?
Precisely. Zero gray area. So the fee structure changed on March 1st, 2026. If you are filing for premium processing, you absolutely must use the new fee amount.
But wait, the trap isn't just knowing the amount, is it? Anyone can look up a number and write a check.
No, the trap is the postmark.
Okay, let's game this out so people understand. Say I'm a researcher. I finish prepping my application on, let's say, February 27th.
Okay.
I write the check for the old amount because technically it's still February.
Yep.
I put it in the office mail pile. But the mailroom is backed up.
Yeah.
They don't actually get it to the post office until Monday, March 2nd. What happens?
You are rejected.
Even though I physically wrote the check in February.
Even though you wrote it in February. The rule is strictly, ruthlessly based on the postmark date. If that envelope is stamped March 2nd and it contains the old fee, DHS rejects the entire filing.
And they don't just, like, bill you for the difference.
No. And this is what shocks people so much. In the commercial world, if you underpay a regular bill by $50, they just add it to your next statement.
Right, it's just a late fee.
But in this system, they physically return the whole package to you. And think about the timeline there. By the time they process the rejection, mail the physical package back, and it lands on your desk, 2 or 3 weeks might have passed.
Wow, and in those 2 or 3 weeks, your legal grace period could completely expire.
Exactly. Or maybe your start date for a new job has passed, and now the employer has to issue a brand new offer letter. It's a cascading failure, all caused by a single mailroom delay.
That is incredibly unforgiving. So the takeaway there is obvious. If you are anywhere near a fee change deadline, you probably need to be overcautious.
Overcautious is the only way. You might even want to wait a day and just pay the new higher rate just to be perfectly safe.
Yeah.
Or ensure you are physically walking that envelope into a courier center yourself, where you can literally verify the date stamp on the receipt. Do not trust the office outbox.
Do not trust the outbox. Got it. Okay, trap number 2. And honestly, this one drives me crazy just reading about it in the legal research. Addition control.
Yes, the silent killer of applications. USCIS is notoriously strict about form versions. Every single form has an addition date. It's usually hiding in the fine print down in the bottom corner.
Right. And they update these things fairly often. And sometimes it's a major overhaul, but other times it feels like they literally just moved a comma.
And that is exactly the problem. The legal research highlights the application for employment authorization as a classic example of this.
Okay.
Let's say you applied for your EAD 2 years ago. You still have the PDF saved on your laptop.
Right. It's already half filled out with your name, your address, your history.
It's super convenient.
I do this all the time with my tax forms. Why reinvent the wheel?
Because in immigration, that wheel expires. Our team pointed out a past example with the August 25, 2020 edition of that form. If you use a saved file, but the government quietly released a new edition last month, your application is dead on arrival.
Even if the questions are exactly the same.
Even if the questions look identical to the naked eye, the scanning system looks for that specific edition, date, or barcode. If it doesn't match the current acceptable list, it's an automatic rejection. It's essentially a syntax error.
Wow. So the active architect mindset here is basically never trust a saved file.
Never. Always go to the official source, download the fresh PDF that exact day, and compare them. It seems a bit paranoid, but when you look at the research from our attorneys, wrong form addition is a statistically significant reason for rejection.
And it's a totally unforced error.
Completely preventable.
Okay, trap number 3. And this one feels a bit more ominous, honestly, because it's about what happens after you make a mistake.
The shrinking safety net.
Yeah. Tell us about this rule.
So this is the Department of Justice interim final rule regarding the Board of Immigration Appeals, the BIA. It went into effect on March 9th, 2026. The government officially calls it streamlining.
And streamlining usually means we want to get through these faster, so stop complaining.
Essentially, yes. The critical change here is that review on the merits is becoming discretionary.
Okay, let's break that down for the listener.
Oh.
What does discretionary review actually mean for someone who just got a denial?
Well, previously, if you appealed a decision, there was a procedural expectation that the board would actually look at the facts of your case, the merits. They would ask, did the officer make a mistake? Is this person actually qualified?
Right.
But now the language suggests the board has the discretion to simply decide whether to review it at all.
Wait, so they can basically just look at it, say, we aren't going to look at this, and that's the end of the road.
Yes. It creates a drastically higher barrier. It signals a massive system-wide shift toward backlog management. They just want to clear the deck. And for the applicant, this completely changes your risk calculation.
Because you used to be able to think, well, if the officer misreads my file, I can always fix it on appeal.
Exactly. And now you have to assume you only get one shot. The initial filing has to be absolutely bulletproof because the safety net of the appeal is being pulled higher and higher out of reach.
Man, this paints a pretty intense picture. You've got strict fees, strict forms, and basically no safety net. It really begs the question, why is the government doing this? Is it just bureaucratic cruelty? Or is there a logic to the madness?
It feels very personal when you're going through it, but it's actually structural. It's the economy.
Feeling lost in a maze of visa types and paperwork? Don't know where to turn? We've got your back. With clear answers and real help, we'll guide you every step of the way. Let's navigate it together. Your journey starts today.
Hello, you must be Clara. Welcome to the law office of Chris M. Ingram.
Finally, I found a law firm that will help me achieve my American dream.
At this law firm, you are important to us. That's why we will be with you every step of the way. So join us at the office of Chris M. Ingram.
Attorney Chris Ingram's team provided some incredible data from the National Bureau of Economic Research, the NBER, that explains the why behind this obsession with speed.
Because usually when we talk about immigration speed, we sort of cynically assume they want to slow things down just to keep people out.
Right, but actually right now the economic imperative is to get high-value output into the country as fast as possible, but they are trying to process a massive volume to do it. The NBER data is fascinating.
Lay it on us.
Immigrant inventors make up just 16% of the U.S. workforce, but they produce nearly 25% of the total innovation output.
Wow. That is a massive multiplier. 16% of the people are delivering a quarter of the country's new technology and patents.
Exactly. And the government knows this. They know that to win the global tech race, they absolutely need that 25% output. So the streamlining and the ultra-strict rules are an attempt to separate the easy, perfect approvals from the messy ones.
Ah, so they want to greenlight the clean cases instantly to fuel the economy.
Yes. So if your case is messy, if you have the wrong fee or the wrong form, you're basically clogging the gears of this economic engine, and the system just ejects you so it can keep moving.
That's a really helpful analogy. The system is optimizing for throughput, not for mercy.
Not at all. Attorney Chris Ingram put it perfectly in the research notes. The strategy has to be slow down just enough to file cleanly.
Slow down just enough to file cleanly.
Because if you rush to try and meet the speed of the system, you'll likely make the very error that gets you ejected.
It's counterintuitive. To survive a fast system, you have to be the slow, methodical one.
Precisely.
Let's zoom out a bit. We've been talking a lot about the actual mechanics of filing, but we need to talk about the atmosphere we're filing into. It's early 2026. The economy is, well, it's weird.
Weird is a very fair assessment. Our legal research pulled comments from Federal Reserve Chair Jerome Powell back on January 28, 2026.
Right, I remember that.
He noted that the economy is on firm footing, but inflation remains somewhat elevated.
Inflation is the guest that just won't leave. But how does Jerome Powell worrying about the price of milk actually affect a software engineer's visa petition?
It's a very direct line, actually. When inflation's high, the Fed and policymakers are terrified of what they call a wage price spiral. They don't want wages rising uncontrollably across the board because that just fuels more inflation.
Okay.
But at the same time, they desperately want high-skilled immigrants to drive innovation.
So they're caught in the middle.
Exactly. And the compromise they've landed on is wage-weighted selection. You see this across the board in recent policy discussions.
What does that mean in practice?
The government starts using your salary as the primary proxy for your skill level. If you have a high salary, the government assumes you are a high-value asset that justifies the inflationary risk.
Yeah, if you don't.
If you have a lower salary, you look like cheap labor that might undermine the domestic market.
Wow. So your salary negotiation with your employer isn't just about your bank account anymore. It's literally about your immigration viability.
Correct. In this climate, a higher salary is a much stronger shield. It signals to the adjudicator that you are that exact innovation asset the NBER report talks about, not just a commodity worker.
And this brings us to a really interesting split in the job market right now. The research highlights a stark divergence. On one hand, the general job market has really cooled off.
Yeah, total job postings finished 2025 just 6% above their baseline.
Right. So if you're in a generic role, it's pretty tough out there. But then you look at the artificial intelligence sector.
The numbers there are just absurd. Indeed, Hiring Lab reported that by the end of 2025, job postings mentioning artificial intelligence were 134% above their 2020 levels.
134%. So while the rest of the economy is just lightly jogging, AI is absolutely sprinting.
Sprinting. And this creates a massive opportunity for that active architect mindset we mentioned earlier. If you are a STEM professional right now, you cannot just present yourself as a generic engineer anymore.
Because the market is shouting that it values AI skills.
Exactly.
So even if your official title isn't AI researcher, you need to find the AI angle in the work you're already doing.
You have to. Maybe you use machine learning to analyze your biological data, or maybe you develop algorithms for structural engineering. You need to pivot your narrative to align with that 134% growth curve.
Because that's where the employer sponsorship is.
And that's where the government interest is. Remember the NBER research again. Our team pulled a specific stat from researchers Shai Bernstein and Rebecca Diamond. They found that immigrants are responsible for 36% of aggregate U.S. innovation.
36%?
And crucially, that innovation spills over to benefit native-born collaborators.
Right, so it's not a zero-sum game. You being here actually makes the rest of the team more productive.
Exactly. But here's the catch, Chanel. You have to connect those dots for the officer reviewing your file. You cannot assume they know your value just by looking at your degree.
You have to spell it out.
You have to explicitly show them, I am working in this high-growth AI sector. I command this specific wage because of my specialized skills, and my work directly contributes to this critical innovation output.
That is the shift from playing defense to playing offense.
Yes.
Playing defense is just checking the boxes and hoping they don't find a typo. Playing offense is saying, here is the undeniable economic argument for why I need to be here.
That's it. You stop asking for a favor. You start offering an asset.
And honestly, that mindset shift seems like the only way to keep your sanity through all this. Because if you just focus on the traps, the postmarks, the edition dates, the lack of appeals, you'll just feel small.
You'll feel like a number. It's so easy to feel gaslit by the bureaucracy. You get a rejection because of a $10 fee difference, and you start thinking, maybe I just don't belong here.
But the data says the exact opposite.
The data says the U.S. economy is desperate for you. It completely relies on that 25 to 36% innovation output to stay globally competitive. The bureaucracy is just a clumsy gatekeeper.
Chris Ingram had a quote in the legal research that I really loved. He said, "You belong in the rooms where you're doing real work and solving real problems."
Yeah, is the anchor right there. When you are fighting with a PDF at midnight, you have to remember that. You belong in the lab. You belong in the server room or the boardroom. Do not let uncertainty convince you that your future is smaller than your potential.
The paperwork is just the toll booth.
Exactly. Pay the toll, check the date, and drive through.
But check the date twice.
Check it 3 times.
So, to wrap this up into a clear strategy for you listening, Step 1, respect the friction. Don't roll your eyes at the forms. Treat them with the exact same seriousness as your code.
Step 2, watch the macro trends. Inflation means your salary matters more than ever. Negotiate accordingly.
Step 3, align with the boom. Use the AI surge to frame your skills as essential, not just functional.
And finally, don't rely on the safety net. The new appeals rules mean you have to get it right the very first time. Be the active architect of your case.
Be careful, but be confident. I think that's the perfect mantra for 2026.
It really is the only way to navigate this landscape.
So before we read out the final outro, here's one last provocative thought for you to mull over. We've talked a lot today about how strict and punishing these bureaucratic traps are.
Yeah.
But what if that friction isn't just a byproduct of a broken system? What if the ability to meticulously navigate this impossible paperwork is actually the first unofficial test of the exact kind of resilience and problem-solving the U.S. economy is trying to select for? Just something to think about as you architect your case.
That is a really fascinating way to look at it.
Thank you so much for being with us today. We hope you gained a lot from this discussion. Please leave us a comment if you can. Additionally, you can support our channel by sharing it with your friends and family, helping us build this community together.
Also, follow us on Spotify, YouTube, LinkedIn, Facebook, X, and Instagram, where we're growing rapidly thanks to our social media team.
We would also like to thank attorney Chris Ingram and his dedicated team once again for researching and preparing this material for our presentation.
See you next time on Let's Talk U.S. Immigration. Bye for now.